Welcome back to the Deep Dive. We're here to take dense legal documents, legislative proposals, and really break them down so you know what they mean.
And today we're tackling something pretty extraordinary. It's a draft bill called the Family Justice and Accountability Act, the FJAA. And, well, it's not really about small tweaks.
No, not at all. It's a sweeping overhaul proposal. Our mission today, to really dig into the FJA's most, you could say, radical idea. Can we actually remove the legal immunity that protects judges, CPS workers, all these state actors, when they knowingly violate constitutional rights?
Yeah, the FJAA doesn't just want to limit immunity, it's aiming to get rid of it entirely. It's about personal accountability, right across the whole family court and child welfare system.
And the language right from the start in the preamble, it sets a really serious tone. It basically says family courts have failed. Failed at their original goal of, compassion, focusing on the child.
Right. Instead, the act calls them, and this is a direct quote, engines of trauma, injustice, and state-sponsored family destruction. It doesn't mince words about the scale of the problem it sees.
And crucially, it frames this as an emergency. Like right now, there's an emergency declaration in the bill. It talks about an urgent and ongoing crisis of kids being wrongfully removed.
And so it's written to take effect immediately, like the moment it's enacted. States would have just 30 days, a really tight window to get their policies in line with these federal constitutional standards.
Wow, okay, so no easing into it.
No, it's basically saying the current situation is unacceptable and has to stop, well, immediately.
Okay, so let's unpack this immunity thing. Before we get into how the FJA wants to tear it down, we need to understand what it actually is and where it came from. Let's start with judicial immunity.
Okay. And the first key point the FJAA makes is this immunity. It's not actually in the U.S. Constitution.
Really? Not explicitly mentioned?
No. The Act traces it back to English common law, the idea of the King's Court, that sort of thing.
Yeah.
It got brought over into the U.S. system, and then case law really solidified it, especially a Supreme Court case from 1872, Bradley v. Fisher.
Right, Bradley v. Fisher. That's the one that basically said judges are protected from civil lawsuits for their judicial acts.
Exactly. Even if they acted maliciously or, beyond their proper authority, that was the ruling.
And the traditional argument for that is?
Well, the idea was, and still is for many, that judges need protection from constant, maybe frivolous lawsuits, that without it, they couldn't be independent or make unpopular decisions.
But the FJAA sees it differently.
Completely. It calls it a self-bestowed immunity. Basically, arguing judges gave themselves this protection, putting them above the very law they're supposed to uphold. And the Act says that's fundamentally against due process.
Okay, so that's the judges. But then there's this other layer, qualified immunity. And that protects a much wider group, right? CPS workers, police.
Qualified immunity is the big one for most state employees. It's the main defense they use if someone sues them under the federal civil rights law, 42 U.S.C. Section 1983.
Section 1983?
Yeah.
That's the law that lets you sue state officials if they violate your constitutional rights while they're on the job.
Precisely. When they're acting under color of law, as the statute says. But qualified immunity puts up a huge barrier.
Which is?
The person suing has to show the official violated a clearly established constitutional right. And that phrase, clearly established, is the really high hurdle.
Why is that so difficult to prove?
Well, the Act really drills down on a 2009 Supreme Court case, Pearson v. Callahan. This decision gave courts a kind of shortcut.
Shortcut? How?
It allowed courts to dismiss a case based on qualified immunity just by saying the right wasn't clearly established enough. And here's the kicker. They could do that without actually deciding if a constitutional right was violated in that specific instance.
Wait, let me get this straight. A court can say, we're not going to rule on whether your rights were actually violated here.
Yeah.
Because the law wasn't crystal clear on this exact scenario beforehand. So the official is immune.
That's exactly it. And the FJAA argues this has, and I quote, materially slowed the development of new constitutional precedent.
It sounds like a catch-22.
It really is. How can a right become clearly established if courts keep dismissing cases before establishing it? It means misconduct can continue because there's no definitive ruling saying this specific action is unconstitutional.
So the first person to experience a specific kind of violation often has no legal way to hold the official accountable.
That's the problem the FJAA sees, and it tries to use the Constitution itself to get around this. It leans on a very old Supreme Court case, Norton v. Shelby County from 1886.
Okay, Norton v. Shelby County. What's the core idea there?
It's pretty fundamental. An unconstitutional act is not a law. It confers no rights. It is in legal contemplation as inoperative as though it had never been passed. Basically, if an act violates the Constitution, it's legally void. It never had any power to begin with.
Void from the start, ab initio.
Exactly. Null and void, ab initio. And the FJAA takes this principle and applies it directly to family courts.
How does that work in practice under this proposal?
It declares that any state law, any court rule, any judicial practice, including a judge's order that violates fundamental constitutional rights like due process or the ADA or federal civil rights, it's automatically considered null and void.
So even if a judge issues an order, if that order is unconstitutional, the FJAA says it's legally meaningless.
Correct. And if the order itself is legally null, then the argument is that claiming judicial immunity based on that null order doesn't make sense. An immunity claim can't protect an action that the Constitution renders void.
So the unconstitutional act effectively cancels out the immunity claim for that act.
That's the legal theory the FJAA is built on. It's using the Constitution's supremacy to argue that state-level immunities can't shield federal constitutional violations. It's a pretty bold legal maneuver. And that foundation, the idea that unconstitutional acts are legally void, really sets the stage for what the FJAA calls the accountability revolution in Section 2. This is where it gets down to the nuts and bolts of stripping away immunity.
Right. This is where Section 3.6.5 comes in, the part our listener specifically asked about. This sounds like the absolute core of the change.
It absolutely is. Section 3.6.5 directly targets that Pearson decision we talked about. It states very clearly, judges, attorneys, CPS workers, court-appointed professionals, they shall no longer have immunity from civil or criminal liability for legal violations. Full stop. Especially constitutional violations.
No immunity. That's huge.
Yeah.
Because historically, these roles had significant protection for their official actions.
Exactly. Discretionary acts were largely shielded. This flips the script. It imposes personal liability, particularly if the violation was done knowingly.
Okay, let's list who loses this protection. The act is very specific, and the list itself tells a story about where it sees the problems lying.
It's comprehensive. Obviously, judges are first on the list. But then it includes all those court-appointed professionals, guardians ad litem, the GALs, attorneys appointed for the child, custody evaluators, therapists involved in the case.
Why single out GALs and other court appointees? Aren't they meant to be neutral?
The source material argues that, intended neutrality aside, they often become part of the system, protected by what's called quasi-judicial immunity, basically an extension of the judge's immunity. The FJAA says if their recommendations are biased, maybe not based on sound science, and knowingly violate rights, they should be personally liable, just like the judge.
Okay, so judges, court appointees, who else?
State and private agency workers, so your CPS investigators, foster care agency staff, adoption organizations.
And even private citizens.
Yes, if they're involved. Foster parents, even potentially adoptive parents, if they are found to have actively participated in a wrongful seizure or concealment of a child, knowing it was unlawful.
Wow. And it goes even further, right, to professionals on the periphery.
It does. Licensed mental health providers used in these cases, and specifically it calls out healthcare professionals, doctors, nurses. If they facilitate an unjustified removal, say, by signing off on a questionable medical report used to take a child, or participate directly in a removal that violates rights, under the FJAA, they wouldn't be immune either.
So being a licensed professional, acting as part of a state process, doesn't automatically shield you if your actions contribute to a constitutional violation.
That's the message. Your professional license doesn't override the Constitution if you're acting for the state.
Let's talk penalties. Because the FJAA isn't just talking about civil lawsuits for damages. It gets into criminal territory, and it gets severe.
Oh, absolutely. This isn't about fines you can just budget for. The Act treats causing family destruction through knowing misconduct as a serious felony.
How serious?
We're talking potential imprisonment. Up to life in prison if the misconduct, say, a judge's unconstitutional order or a CPS worker's fabrication directly leads to a child's death or severe or permanent harm. And that includes sexual abuse while in state care or profound, lasting psychological trauma.
Life imprisonment for a judge.
Yeah.
For a social worker. That is a staggering potential consequence.
It's designed as the ultimate deterrent, and it's not just discretionary sentencing at the top end. The Act includes mandatory minimums for specific actions.
Like what?
A mandatory 5-year minimum prison sentence for any one judge, GAL, CPS worker who ordered or, helped make happen a forced reunification of a child with someone they knew was a credible abuser. Or conversely, denied protection when a child was clearly in imminent danger from an abuser.
That removes the judge's ability to give a lighter sentence in those specific high-risk scenarios.
Exactly. It targets situations where the system is often criticized for failing to protect kids from known dangers.
Now, I have to raise the counter-argument here. Critics would immediately say that threatening judges and social workers with life sentences and mandatory minimums, won't that just paralyze the system, make good people afraid to even take these jobs or make any decision for fear of prosecution, even if abuse is happening?
That's definitely the pushback you'd expect. And the FJAA source material seems ready for it. The argument embedded in the Act is that it only targets knowing violations of constitutional rights. It's not about punishing honest mistakes made in good faith.
So the standard is knowing violation.
Yes. The FJAA's position seems to be following the Constitution isn't optional for public servants. The choice isn't functional system versus paralyzed system. It's system above the law versus system under the law. Fear of consequences for knowingly breaking the law shouldn't stop someone from doing their job lawfully.
Okay. Beyond prison time, what about civil lawsuits and professional consequences?
Civil suits are broadened. Families can sue for a whole range of damages. Emotional distress, obviously, physical injury if it occurred, but also things like the loss of relationship, those lost years of family connection, and even economic damages like loss of career or income if a parent was wrongfully targeted.
And the professional consequences sound career-ending. Forfeiture.
Yes. Permanent ban from holding public office again, and crucially, forfeiture of public pensions and professional licenses for any state or county employee found liable under the Act.
Losing your entire pension.
Yeah.
That's huge.
For a career state employee, that's potentially devastating. It's designed as maybe the ultimate financial deterrent. Hit them where it hurts, essentially.
And Section 3.6.7 kind of ties a bow on this section, explicitly saying immunity doctrines can't be used to block people from seeking justice for constitutional violations.
Exactly. It hammers home the point. Governmental bodies and their employees don't have superior rights to the citizens. It fundamentally rejects the idea that claiming immunity can just erase a constitutional harm.
So the old excuse of, I was just following orders, or I was just doing my job.
The FJAA explicitly says that's no longer a defense if those orders or that job involved knowingly violating federal constitutional rights, ADA rights, or even broadly defined human rights standards. If you knew, or reasonably should have known, your actions were unlawful and caused harm, this act says you are personally responsible. The shield is gone.
Okay, so removing immunity puts the pressure on individuals. But the FJAA doesn't stop there. It also attacks the structures that allowed these problems to fester, starting with how the system polices itself. Or rather, how it doesn't.
Right. The Act is deeply critical of current judicial oversight, things like judicial conduct committees. The critique is they're usually made up of judges judging other judges or lawyers closely tied to the system. It's seen as inherently self-protecting.
So what's the FJAA's fix?
It mandates, immediately upon enactment, the creation of an independent oversight committee.
Independent how? What makes it different?
The members. It's comprised only of members of the public. Crucially, no current or former judges, no attorneys, no court employees allowed. It's meant to be a complete firewall against insider bias or conflicts of interest.
A citizen oversight committee for judges. What power would it actually have?
This is a massive shift. The committee would have exclusive authority to rule on issues of judicial bias, conflicts of interest, and whether a judge needs to recuse themselves, meaning step aside from a case.
Exclusive authority.
Yeah.
So the judge doesn't get to decide if they're biased anymore.
Nope. The public committee decides. And if they find bias or a conflict, the judge must recuse. It's binding. It completely changes who holds the power over judicial impartiality.
That is seismic. And speaking of shifting power back towards the public, the Act also talks about bringing back juries in family court.
Yes. Right now, almost all family court cases involving custody or termination of parental rights are bench trials. Just the judge decides.
Yeah.
The FJAA proposes reinstating the federally protected right to a trial by jury.
For any case where custody's on the line.
Any proceeding where a parent faces losing custody or having their rights terminated entirely. The idea is that taking someone's child away is such a drastic state action, akin to taking liberty, that it shouldn't be up to one potentially biased government official. It should be decided by a jury of the community's peers.
That ties in really well with the next big push in the Act, transparency. Section 6 sounds like it wants to floodlight the whole system.
Absolutely. The phrase "sunlight is the best disinfectant" comes to mind. This section mandates radical transparency in areas that have often been very closed off.
How? What are the mechanisms?
First, technology. Mandatory body-worn cameras for basically everyone interacting with families in an official capacity, CPS workers doing home visits, GALs doing interviews, evaluators, even courtroom personnel during proceedings.
Body cams in the courtroom. On social workers, I imagine there'd be huge pushback on that.
Oh, almost certainly. But the Act's logic is clear. If we require police officers who use physical force to wear cameras, why wouldn't we require state actors who wield the immense power to destroy families to also record their interactions?
And what happens with all that footage and other records?
They must be preserved as public records. All notes, reports, recordings of hearings, interviews, everything. And families must have free, immediate, and complete access to all of it. The Act explicitly cites legal principles like Brady v. Maryland and FOIA, the Freedom of Information Act.
Can you quickly remind us what the Brady principle means here?
Sure. Brady v. Maryland is a landmark criminal case saying prosecutors must turn over any evidence they have that could help the defendant's case, exculpatory evidence. The FJAA applies that logic to family court. It treats the parents as, essentially, defendants whose fundamental rights are at stake. So if CPS has notes or a GAL interview recording contains something that helps the parent's case, they have to get it. No hiding the ball.
Okay, transparency through recording and access. What else? There's something about names.
Yes, the abolition of pseudonyms. Right now, in many places, judges, social workers, GALs might operate under a badge number or a pseudonym in official documents, often citing safety concerns.
And the FJAA says no more.
No more. It mandates that all government officials involved must use their full legal names in all official capacities and records. The argument is that accountability requires transparency. The public and the families involved have a right to know exactly who is making these life-altering decisions, to track their records, identify potential conflicts of interest. Hiding behind a pseudonym, the Act argues, facilitates misconduct.
This accountability push extends upwards too, right? To the federal level. The Department of Justice.
Yes. The FJAA includes findings criticizing the U.S. Department of Justice, the DOJ. It states the DOJ is often claimed it lacks resources to properly investigate complaints about civil rights violations or, significantly, ADA violations happening in state family courts.
So the FJAA sees the DOJ as having failed to enforce federal law in this area.
Pretty much. It treats that lack of resources claim as an unacceptable excuse for inaction.
And what does the Act propose to do about it?
It puts the DOJ on a clock. Mandates they have to review, investigate, and formally respond to these kinds of complaints within 90 days.
And if they don't?
Consequences. Automatic congressional oversight hearings. Heavy fines, a minimum of $250,000 per instance of failing to act. And, really importantly, it explicitly gives victims the right to sue the federal government itself under the Federal Tort Claims Act, FTCA, for failing to investigate.
So the federal government can no longer just ignore complaints about state-level abuses in family court without facing potential consequences itself.
Exactly. It aims to eliminate that layer of federal inaction that, the Act implies, has allowed state-level problems to persist.
Okay, let's shift focus to how the FJAA specifically tries to protect families during these processes. It takes aim at certain practices it deems harmful, starting with what it calls pseudoscience in expert testimony.
Yes, this is a major target. The Act specifically prohibits and even criminalizes the use of theories like Parental Alienation Syndrome, PAS, or similar concepts like malicious mother syndrome.
Why such a strong stance against PAS?
The Act states flatly that PAS is scientifically discredited. It's not recognized as a valid diagnosis by major medical or psychological bodies like the American Psychiatric Association or the AMA, yet it argues this concept is frequently used in court.
Used how, according to the source?
Used to undermine credible allegations of abuse. Often, the parent reporting the abuse, usually the mother, is accused of alienating the child against the other parent. The Act finds this tactic has led to disastrous outcomes.
Like what? Does it provide numbers?
It cites a figure. Over 58,000 cases annually where custody was wrongfully reversed based on these kinds of alienation claims, often resulting in the child being placed with the parent they had accused of abuse.
So the FJA doesn't just say judges shouldn't consider PAS. It says using it can be a crime.
Yes. If an expert witness, a GAL, or even a judge relies on PAS or similar discredited theories to dismiss abuse claims or justify separating a child from a protective parent, and that action leads to harm, they could face liability, including those mandatory minimum sentences, if it results in placement with an abuser.
And it protects the parent reporting abuse.
Explicitly. It says protective parents cannot be retaliated against, labeled unstable, or have unrelated disabilities weaponized against them simply for making a good faith report of abuse.
That brings us neatly to the Americans with Disabilities Act, the ADA. This seems like a really central pillar of the FJAA.
It is. The Act argues ADA compliance in family courts is systematically ignored and treats this as a major civil rights issue. It takes a really interesting view on trauma, too.
How so?
It recognizes that the very act of forcibly separating a child from a parent, especially a protective one, often creates disabilities. Things like severe PTSD, attachment disorders, crippling anxiety, or it makes existing disabilities much worse.
And these children, harmed by the state's actions, are then entitled to ADA protections.
Exactly. Full protection and necessary accommodations under federal law.
How does the FJAA plan to enforce ADA compliance within the court system itself? Because often it's judges making decisions about accommodations.
Well, the FJAA takes that power away from judges entirely. It explicitly prohibits judges from ruling on, modifying, or denying requests for ADA accommodations.
Who decides then?
The Act mandates that every judicial district must have a certified ADA compliance officer. That officer, a trained professional, is responsible for assessing needs and implementing necessary accommodations. The judge has no say in it. It's meant to be an objective professional process, not subject to judicial whim or bias.
Another example of shifting power away from the judge to a mandated process.
Precisely. And these ADA protections aren't just for the kids. They extend to parents with disabilities, too.
In what way?
The Act is very clear. Having a disability, whether it's physical, mental health like PTSD or anxiety or neurodivergence, cannot, by itself, be used as grounds to deny custody or parentage. Courts must provide reasonable accommodations to ensure parents with disabilities can equally participate in proceedings and maintain their relationship with their children.
Okay, beyond ADA and pseudoscience, let's talk about the actual standards for removing a child and where they can be placed. There's a strict rule about placement with abusers.
A very strict prohibition. Section 5 explicitly forbids courts from placing a child with someone who is credibly accused or known to be an abuser, especially if that placement also means cutting off contact with the safe, protective parent. Doing so is defined as a violation of the child's welfare and could trigger that criminal liability for the judge or GAL involved.
And the standard of proof the state needs to meet before they can remove a child in the first place, it's radically changed.
Radically. It throws out the usual civil standard of preponderance of the evidence, or even the slightly higher, clear and convincing evidence as traditionally understood.
So what is the standard under the FJAA?
The state must prove, by clear and convincing evidence beyond a reasonable doubt, that the child faces immediate and substantial harm if they remain in the home.
Okay, clear and convincing evidence beyond a reasonable doubt. That sounds like combining two different legal standards. How does the Act define that? Does it give a number?
It does, and this is maybe one of the most impactful parts of the entire Act. It defines this standard as requiring 97% certainty.
97% certainty. That's incredibly high. Where does that number come from?
It's essentially importing the highest criminal standard beyond a reasonable doubt into family court. The rationale presented in the source is that terminating parental rights is the civil death penalty. It permanently ends the family unit. Therefore, the state should have to meet the same near-absolute level of certainty required to convict someone of a serious crime before taking such an irreversible step.
What would 97% certainty mean in practice for CPS?
It would make removals based on anonymous tips, vague suspicions, or just ticking boxes on a risk assessment form almost impossible. They'd need concrete, verifiable evidence. Forensic evidence, direct observations, maybe multiple credible witnesses demonstrating immediate substantial danger to that near certain level. It completely shifts the burden. Instead of the family having to prove they're safe, the state has to prove, almost beyond any doubt, that they're not.
The Act also mentions giving more weight to the child's own words.
Yes. For children under 10 who disclose abuse, Their disclosure is to be presumed credible and given significant evidentiary weight. No more easily dismissing a young child's account.
And interviews with kids.
Must be audio and video recorded, and those recordings must be made available to the parents. This stops the practice of relying on summaries of secret interviews that the parents can't verify or challenge effectively.
All right, moving into the final major area. The FJAA goes after what it sees as the financial incentives that corrupt the child welfare system. And it starts with a big target, ASFE.
Yes, the Adoption and Safe Families Act of 1997, the FJAA calls for its complete repeal.
Why repeal ASFE? What's the argument against it?
The argument is that ASFE created perverse financial incentives. It provides federal funding block grants, bonuses to states based on the number of adoptions they finalize out of foster care. The FJAA contends this has created a profit-driven child welfare industry where the focus shifts from helping families start together to terminating parental rights quickly to meet adoption targets and secure federal dollars.
Is it mainly the funding or also the timelines ASFE imposed?
Both are linked. SFA famously introduced the rule that states generally must move to terminate parental rights, TPR, if a child has been in foster care for 15 out of the most recent 22 months.
Right, the 1522 rule.
The FJAA argues this arbitrary federal deadline often forces TPR prematurely before parents have had a fair chance to address the issues that led to removal, simply to meet the timeline and free the child for adoption, thus triggering the financial incentives.
So the FJAA wants to scrap SFA entirely and redirect funding.
Yes. Repeal SFA and mandate that any future federal child welfare funding must prioritize family preservation, reunification services, and supports to keep families intact, rather than incentivizing adoption quotas.
Okay, beyond SFA, there's a really striking section, Section 38, about the financial commodification of children. The language here is incredibly strong.
It is. Section 38 makes it illegal to issue, create, or trade any kind of financial instrument like a bond or a security where the payout is tied to the outcome of a custody case, a foster care placement, or an adoption.
Tying financial products to custody outcomes, is that something that actually happens?
The Act asserts that structures potentially exist or could be created that effectively allow investors to bet on or profit from the movement of children through the system. The FJAA wants to preemptively outlaw this entirely.
And it doesn't just call it illegal, it classifies it using some very heavy federal statutes.
Extremely heavy. It explicitly classifies creating or trading such financial instruments as a violation of federal human trafficking laws and the RICO Act.
ICO, the Racketeer Influenced and Corrupt Organizations Act. That's usually for organized crime, the mob.
Exactly. By invoking RICO, the FJAA is making a profound statement. It's saying that if financial systems are set up to profit from the processing and placement of children in state custody, that isn't just unethical, it constitutes systemic, organized criminal corruption and trafficking, punishable under one of the most powerful federal laws available.
That completely reframes the issue from mismanagement to potential federal racketeering.
It's intended to get the attention of federal prosecutors and regulators, demanding they look at the financing of child welfare through that incredibly serious lens.
Let's quickly loop back to law enforcement. We mentioned officers lose immunity if they enforce an unlawful order. What's their positive duty before they remove a child, according to the FJA?
They have a duty to verify. Before executing any court order for child removal, they must take steps to confirm its legality and constitutionality. Does the court have jurisdiction? Is there a proper warrant if required? Has ADA compliance been verified if applicable?
So they can't just blindly follow the piece of paper the judge signed?
No. The Act states their duty is to protect and serve, which includes protecting constitutional rights, not merely enforcing court orders, especially if those orders appear unlawful on their face. If they proceed with a removal based on an obviously faulty or unconstitutional order and harm results, they can't just blame the judge. They face potential liability, too.
The just following orders defense is explicitly removed for constitutional violation.
Correct.
And finally, the Act tackles the role of the State Attorney General's office. How does it change that relationship?
Historically, the AG's office in most states automatically defends state employees, including judges, when they get sued, even for alleged constitutional violations. The AG acts as the judge's lawyer, paid for by the taxpayers.
The FJA stops that.
It prohibits that automatic representation in cases alleging constitutional misconduct by a judge. It argues the AG's primary duty is to the public and the Constitution, not automatically to defend state officials accused of violating rights.
So what should the AG do instead?
The Act mandates AG offices set up a dedicated public protection division specifically to investigate judicial misconduct complaints and, potentially, to represent the public's interest against state actors who have violated the law. It aims to break that protective alliance between the judiciary and the state's top lawyer.
Okay, we've covered a huge amount of ground here. The abolition of judicial and qualified immunity for knowing violations, potential life sentences for misconduct, mandatory minimums, citizen oversight committees, body cameras, the 97% certainty standard, repealing SFA, invoking LMCO. It's a lot.
It really is. If you boil it down, the FJAA's central message is this: the shields are down. The immunities that the Act argues have protected systemic abuse for decades are being systematically dismantled in their place. Direct, personal accountability, civil and criminal, for every single person acting under the authority of the state in these cases.
Judges facing prison time, losing their pensions, CPS workers needing near absolute proof before acting, courts facing massive fines or public shaming for noncompliance.
And the core legal principle driving it all, especially Section 3.6.5, is that the Constitution applies inside the family courtroom. Government officials don't get special rights or protections that citizens don't have. If a judge knowingly breaks the law, knowingly violates fundamental rights,
You can sue. The robe doesn't protect them anymore.
that's the promise. And by framing wrongful removal as a form of state violence, requiring near criminal certainty to justify it, and attaching severe personal consequences to violations, the Act forces a fundamental reckoning.
Which leads us to the final provocative thought the source material leaves us with. With this incredibly high 97% certainty standard and the very real threat of felony charges, prison time, losing everything, how does that change the day-to-day calculations?
Well, judges, social workers, GALs, attorneys approach the decision to remove a child fundamentally differently when the fear of personal ruin replaces the comfort of immunity. What does a child welfare system look like when every single official knows that a knowing violation, a deliberate disregard for constitutional rights, could cost them their freedom?
Does the fear of prosecution become the ultimate check on state power in family court? That's the question the FJA forces us and potentially the entire legal system to confront.